Our CodeX group meeting. We are going to have two guests today. We have Beatrice Marone, who is a doctoral student at the University of Pavia, who will talk with us about computable insurance products and whether they can be recognized under the law of contracts. And then we have, actually we have three guests today, James Ding and Will Seaton, both from DraftWise, will introduce us to what their company is doing in the world of AI-powered knowledge management. And so great folks joining us today. And before we get started, I wanted to see if anyone had any updates to share with the group. All right, great. So Dr. Sharma has a new paper out. Thanks for sharing this to the chat. Emerging Legal Informatics Towards Legal Innovation. So thanks for sharing that link. And yeah, folks, if you want to share any updates, yeah, you can pipe up now by unmuting yourself or by just using the chat function. All right, Mark, did you want to say something too, or?
No, actually, I was starting to put something in the chat, and I hit return too soon, so I'll be quiet.
I see. Okay, go ahead, please. Okay, wonderful. All right, well then let's turn it over to Beatrice.
Thank you so much, everyone. Actually, I cannot share. Okay, I can. You can see me now. Okay, perfect. Yes. So good morning, afternoon, or evening, everyone. I'm Beatrice Marone, and I'm really glad and thankful for this opportunity to be here today. So I'm gonna share my screen with the little presentation that I did about the topic of today. So, okay. So the topic I'm gonna discuss today is, can computable insurance products be recognized under the general law of contracts? So just a quick introduction about myself. I'm Beatrice Marone, and I graduated in law at the University of Pavia in 2020. And I'm currently enrolled in a PhD program in private law at the same university. So since a few weeks, I'm coordinator of the unit of the University of Pavia for LILA, which is the Legal Analytics for Italian Law, and works towards the extraction of knowledge from databases of juridical decisions, with aim of extracting knowledge and then draw logic paths towards predictive justice, hopefully. So I'm also a trainee lawyer and trademark consultant, and since 2018 I'm a qualified Italian publicity journalist. So first of all, where did the interest towards this topic start for me? From my final dissertation, which was called Sustainability, New Horizons for Regulation of Human-Centered Artificial Intelligence and the Role of Jurists. So I wanted to underline two words that are really important to me, and that I want to, and that will be kind of a keywords for my research right now and for what I'll do in the future. So regulation and jurists. So after writing my dissertation, I found out that actually looking for places where jurists could be key roles in regulation of any kind of field or any kind of specific topic could be interesting. So if you fill the blank space with everything that you want, you can find how I'm passionate about this and how I want to work and research more and more in deep towards this topic and more. So jurists, according to me, and also taking the words of Richard Susskind, have to be legal hybrids. So people that can work into an interdisciplinary context. And taking the words from another Professor Santos Wasso, to solve the big challenges that society has to face: energy, water, climate, food, health, scientists and social scientists have to work together. And this is the challenging thing for me, and the thing that pushed me towards a deeper research and a deeper understanding of these kind of topics that tie together experts from different fields of knowledge. So I did a quick research online, and through Google Trends, I tried to find out the actually references towards two kind of locutions, verbal locutions, so smart contracts and computable contracts. So the blue line you can see on the screen is the research in the last year for the word smart contract, while the red line on the screen is the line for, that express the research of computable contracts. So what does that mean? It's not true that no one talks about computable contracts, but as the advice that Google Trends provided to me, the data related to my research were not sufficient, were not enough to be shown there. So what does that mean? This is a simple research online. So it just means that, according to me, few people talk about it. Few people talk about computable contracts, at least right now. So there is no general awareness on them, and there is no even less than awareness. There is no knowledge about them, no knowledge about what they truly are. And for many people that I talked about, computable contracts are the same of smart contracts, and that's not true. So I thought that when there is no knowledge, when there is no awareness, there's also, in most cases, a lot of skepticism. And when there is skepticism, I think that the best way to show that there is nothing to be afraid of, nothing to be skeptical about, is to put the new thing into the traditional categories. And that's why the first leg of my research is focused on the fact that computable contracts, or computable insurance products in specific, can be recognized under the general law of contracts, so under the traditional law of contracts. So what is the general law of contract? It is a mixture of international law, especially international private law, and national law. Most frequently, contracts are based on national law, or are regulated by national law. And these two kind of laws intertwined with each other, have consequences and effects on each other, as we will see in a bit. So what does that mean, be recognized by the general law of contracts? So I tried to draw a kind of a path, step by step, and see if and being guided by some questions. So the first one is, can legal acceptance and assent be represented effectively through electronic means? So the question about electronic signature, which is the kind of the first historical provision of clause in a contract that was represented by code. And then we go on with another question on the step-by-step path towards any kind of clause. So from the specific clause of the signatures to a more general clause, a more generic clause, or any clause in the contract to be represented by code and make an enforceable contract. And then again, from some clauses to all the clauses. So we go to so the representation of the obligation of parties in a mixture of code and natural language. We can talk about Ricardian contract, for example, and we can go on and follow this path until going to the last step in this path that I kind of envision, talking about human-machine contracts. So contract where only one part is human and the other part is a machine. And the key question is still, can a contract with this kind of issues, let's say, or this kind of features, be legally enforceable? So can be validly recognized by the law, by the general law of contracts, so the traditional provisions. So to do this, I tried to do an empirical research, and since it wasn't possible for time and space to investigate the national law of any countries in the world, I tried to focus on some kind of limited territory, territory. So focusing on the G7. The G7 are because it involves countries that are different by cultures, by geographical position, and with different even kind of legal order. So it was like a micro environment, but still very interesting and challenging for the different solutions that were adopted in the States. So this is a timeline that I kind of drawn, and above the line you can find the international legal acts and international provisions with their date that are related to this kind of topic. And under the line you can find the national provisions. So first of all, a little bit of a disclaimer. I tried to find out the provisions talking about electronic contract in general, because as I said, I tried to envision a step-by-step approach. So going from signature to computable contracts, and then computable contracts in insurance. So yeah, the first provision that we can find is from actually 1985, and it's in a recommendation of UNCITRAL, on which was drafted the model law of an electronic commerce in 1996. So the key provision, according to me, is Article 5. So the fact that information shall not be denied legal effect, validity, or enforceability solely on the ground that it is in the form of a data message. And it's important, I think, the choice of a negative form, and the reason why we will see just in a little bit in the last slide. So the first country that actually improved and issued and enacted a piece of legislation towards this topic was the US in 1999 with the Uniform Electronic Transaction Act, the UETA. And the key provision, and a provision that I think is quite trailblazing since it's 22 years old, it's Section 7, and especially Section 7 letter B. So the fact that the contract may not be denied legal effect or enforceability solely because an electronic record was used in its formation. And again, the negative form, which I found really important, really relevant. So if we use the affirmative form, I think that there's still space for exceptions. So the affirmative forms always comes with a space for exceptions, while choosing the negative form, and that was clear also in the reports and in notes of the drafters of this provision, was envisioned exactly towards not envisioning exception to that. So to strengthen even more this provision, which again, I found really trailblazing. So other countries in the G7 that had a quite different approach, but still really interesting for me, were Canada and Japan. So Canada and Japan had some kind of provisions towards electronic signature in specific acts. Canada older, and Japan actually not so old, but they were not specifically related, not to electronic contracts, but not even to electronic signatures. And so the enforceability and the theory of enforceability of electronic contracts, and then again, hopefully, of computable contracts, is based in Canada on the functional equivalence approach, and in Japan on the interpretation of the provisions of the civil code. So basically, what I found from my research is that they think, the interpreters, the doctrine said that if there is the agreement, no matter how this agreement is represented, we have a code, we have a contract. So, and the contract is enforceable because of that. So going to the European Union, I found that the first pieces of legislation about electronic signatures were actually directives that, as we all know, need national implementation. And actually, these two directives come together, let's say, but come even after some national provisions of electronic signature. For example, we have in 1997 both the Italian and the German legislation on electronic signature, while other countries, such as the UK, which is not part of the union anymore, but to which some pieces of legislation, among which these ones still apply, needed them as a push towards national legislation on the matter. And the last one was the regulation. So the choice of the EU legislator to a piece of legislation that did not need national implementation to get the concept even more strong in 2014. So you will excuse me to having reserved one slide only for the case of Italy. So Italy is kind of a problem which revolves around many pieces of legislation. So there is no coherence sometimes, or even most frequently, between pieces of legislation in the Italian legislation. So we didn't follow a path towards signature, from signature to contracts in electronic form, but we had this first provision in 1997. And then in 2018, or better, in the conversion of the law decree of 2018 in 2019, we had the first definition of smart contract, one of the first definitions of smart contract in the world. And the point is that despite this definition has some problems, because we have a juridical concept, so smart contract, which is defined from a technical point of view. So the smart contract is defined as a program for machine that operates on technologies, etc. So this is something on which the Italian legislation really need to focus and really need to reflect on, and for going towards the future, because this kind of provision, in my opinion, does not work right now and won't work even more in the future. So yeah, why I talked so much about electronic contracts. So we went from computable contracts and backwards to find the first provision in the history, to find the first the traditional categories into which put the new topics that we are investigating. Again, in order to face the skepticism that many people still feel towards this kind of tools. And so to go from electronic contracts to computable contracts, and especially to computable contracts in the insurance field, we need to take a step forward. So take a step from private law to public law and vice versa. So as national and international law are intertwined with each other, so are private law and public law. And that's where comes the role of the regulation authorities. So for example, I went to a lecture from representative from the Italian regulation authorities, and she said that we need a synergic effort. We need a synergic effort from all the actors involved in the insurance field. So why the role of regulation authorities? And I'm finishing right now, so just stay with me 1 minute longer. So yeah, I think that there's always it's always good to finish something with a question, because there's never space to stop researching. There's always space to go beyond. So my next question, and the thing that I will focus on in the next month, will be this one. So can computable insurance contracts, given the fact that, as we said, are enforceable under the general law of contract, then receive the necessary approval under the specific insurance regulation regime? So this is what I'll focus on in next month. And I wanted just to finish my presentation with a quote from the CodeX Insurance Initiative that I found some years ago. So, and the reason why I'm so excited and so glad to be researching on this topic and in this environment. So a vision where people, softwares, and services with the help of computers are able to rapidly understand the implication of contracts and laws and make optimal decisions accordingly. So there's no different levels in this quote. So people, softwares, and services, and also computers are all in the same level. And that's what I want to research for, and that's what I want to have as the topic of my research and of my future activities in the future years. So thank you so much.
All right, well, thank you so much, Beatrice. So I'm not quite sure if I understood, what's sort of the status quo. I understand that different jurisdictions have given thought to electronic signatures, but whether they are already thinking about the legal treatment of smart contracts or even already computable contracts.
Yeah, so basically I think as my research is still ongoing, and by the way, if you have any of you have some inputs on their national legislation, I would be more than happy to take them the advices. I think that we are still in a quite early stages in talking about especially computable contracts. Like from my research, I found out that Italy is one of the few countries that have already a definition for smart contracts. So many countries do not have a legislative definition for smart contracts. So I think that there's a lot of things and a lot of path to be followed. Right now, there is so much research going on in doctrine, but at the legislative level, I think we are quite behind. But maybe I'm mistaken. There's still space for researching even farther.
Okay. Well, I think it seems to me that the concept of smart contracts is mostly associated with the blockchain and these programs that are running on the blockchain and, you know, fulfilling some agreement and some obligation. For us, computable contracts, our definition of it is, a computable contract is one that is specified in sufficient detail to provide unambiguous answers to questions about compliance of clearly specified circumstances with the terms and conditions of the contract. And we feel that that technology can, particularly in the insurance field, really help be part of the digital transformation and enabling new kinds of queries for people to understand if they're covered in a certain situation or not. And, you know, for insurance companies to basically to do scenario modeling, to develop new modular products, to do what's known as mass customization of contracts. So we feel there's a huge opportunity there, but there are legal questions that are arising in the context of computable contracts. So one that several people have mentioned is, you know, what if there's litigation about a computable contract? Which version controls? Like, is it the computable version or the human readable version? And how do we ensure that the computable version is faithful to the human readable version? And how is a judge supposed to understand that translation between the human readable version and the computable version? And that said, you know, I mean, the ultimate goal is to create a technology that where you don't need that translation aspect, where you have a coders that translate. You know, you have a lawyer that explains the contract, and then a coder that translates it into a computable form. The future in our mind is that the lawyer, domain expert, will be able to use a specific language to express the contract in a computable form, him or herself. So anyway, so those are some of the questions that have been raised, and I don't think that, you know, lawmakers are at this point sort of given any thought to those issues, but yeah, I might be wrong. But anyway, so does anyone, oh, Diego is asking, is the Ricardian contract a better solution for the issues that may arise during a court dispute?
Oh, the question is for me. Well, yeah, actually, I have only researched like the legislative treatment, so I still have so many space to cover on court disputes. So yeah, based on what I know right now, probably, yeah, yeah, actually, I thought in some countries in the world, like during my research, I found out that many people still do not use recording contracts, still don't even understand quite what recording contracts are, because recording contracts, for what I've learned, are like usually really spread in some places, but not so much in other places. So there's again this kind of let's say no knowledge, so absence of knowledge. So Yeah, probably. I mean, from my background, I'm not the most expert person on that because in Italy, I mean, in my experience, recurring contracts are not that spread. So these kind of questions are not really, again, not really faced neither by courts or by the legislators. I mean, from what I'm now in my research. So yeah, that's what I can say from now. But I will. Write down this question and research and came back when I will have an answer that satisfies me as first.
Yeah, it's if you look it up, it's defined as, you know, digital documents that act as an agreement between two parties on the terms and conditions for an interaction between the agreed parties. And, you know, it's sort of yeah, it's also you know, it's becoming a more popular concept through sort of the use of it on the blockchain. I think Manish has a question. Manish, do you want to chime in?
Yeah, so hello. My question wasn't really like, my question was regarding the comment you made to the computable contracts. And when you mentioned, so this is an association I've been seeing quite often, that when we talk about computable contracts, we see insurance as one of the major use cases. Why is that? Like, why do we majorly talk about insurance and not other domains when it comes to computable
well,
contracts?
I think you know, for us, it's, you know, we've been talking about computable contracts for many years. I think we started one of our earliest projects was a marketplace for IP licenses, which is where we started thinking about you know, so basically a copyright marketplace, which was also a form of you know, computable contracting, and you know, it was called a Stanford Intellectual Property Exchange. The idea was to help universities understand the rights they have already licensed, and then for people who wanted to create a course reader and taking articles to create a course reader, to be automatically sort of filtering out, you know, the rights that the university already has and the rights where they still had to pay, you know, royalties to the authors, right? And so that was an interesting kind of legal informatics project. And it's a form of computable contracting. So this is like 15 years ago, and we have then, you know, entertained a research effort on computable contracts for many years with workshops and white papers. And at some point, we found this opportunity to team up with folks in the insurance industry who really sort of saw, you know, some of the, you know, sort of barriers they're facing in terms of like in their digital transformation, and they realized sort of the shortcomings of some of the data-driven machine learning NLP approaches, and felt sort of that the rules-driven approach is sort of kind of the missing link, and we teamed up. And it's a very exciting area for us because in insurance, really, the contract is the centerpiece of the transaction. You're buying a contract, right? And there's only few other areas where where contracts have such a central role. Like normally, you have a contract, you know, that's sort of like an adjacent document that governs, you know, and then usually you sign the contract and you file it away. So anyway, so that's why insurance is exciting, but it's relevant way beyond that, right? And that's why it's exciting what, you know, what's happening on the blockchain, right? Even though that's not like computable contracts in their full developed to their full potential, it's more just a small sort of glimpse of what's going to happen. But it is demonstrating, you know, this idea of like sort of the operationalizing a legal understanding, and it can be tied to oracles, and you can automate the performance. And so I think it that in itself sort of, you know, really accelerated this idea. But it is still quite different, right, from what we're talking about computable contracts. When we talk about computable contracts, we rarely do so in the context of the blockchain. So anyways,
thank you.
I hope that answered your question. So we're already at the halfway point. I just wanted to see if anyone else wanted to ask a question to Beatrice or anything else on the computable contracts topic before we turn it over.
I think there's a question in the chat from Scott G.K. McLeod asking, I would smart contract for the poor in the future. So I think that the topic of access to justice and access to law in general is really important. And I think that researching on this field can make improve not only the insurance field, which is a need that is really, really felt. And actually also regulators have issued policy papers saying that we need more transparency, more, let's say, language more consumer friendly, let's say. So I think that computable contracts are definitely the next step towards, I don't know, access to law, and not only access to justice, but access to law and to the law field in general for everyone. I mean, that's my opinion, but yeah.
Thank you, Patrick. And I think if we are excited about this technology for that very reason, that we feel it's going to make in so many situations, there are sort of different power imbalances in society, right? And many times, consumers don't know what the contracts say, and many times that's an information problem. We feel computable contracts is a tool to help people get more, be able to operationalize the rights they have and understand them and act on them. And so that's what excites us around computable contracts. It's a great showcase area for computational law, and it can really, I think, empower individuals in insurance and beyond. And so that's why it's exciting. And there are two dimensions to this work, right? I mean, one is like the hardcore computer science work to do this and to translate from human language into computable language. So that's, I should say there's three aspects here. So there's the hardcore computer science work. Then there's the user experience side, the legal design work that's necessary to make those systems user friendly. And then there's the legal work, right? What's the legal treatment of those new kinds of contracts? And so I appreciate you, Beatrice, introducing us to some of the legal issues and the legal framework surrounding computable contracts, specifically as applied in insurance. I really appreciate you joining us and sharing your thoughts. And please keep us posted. And I would like to thank you again. And I'd like to turn it over to our next guests, who are Will, and let me just open my notes here from DraftWise. So again, James and Will. Yeah, James and Will from DraftWise. Are you there?
We're here. Thanks, Roland.
Fantastic. Good to see you. And we're excited to learn from you what you guys have been up to.
Definitely. It's a pleasure to be here for Will and I to introduce everyone to our company, DraftWise. And what we're going to talk about is how we're applying language models to support the drafting of higher quality contracts. So as a company, our mission is really to help law firms use their best contract language, wherever it resides, whoever wrote it, and in doing so, unlock their best competitive advantage, which is the years of experience they have negotiating high quality contract language for their clients. We want transactional attorneys to come to DraftWise when they need answers to questions like, have we worked on something like this before? Or are these terms standard for this contract type in the market? Or what has my client, my partner, or the opposing counsel accepted before? Or just show me options I have for a better language. And we're taking a unique platform-driven approach to this problem that we're excited to talk about. First, a little background on who we are. So this is us. I'm the co-founder and CEO of DraftWise. My background is as an engineer. Before this, I worked at Palantir, where I led engineering on a product team. And I also frequently visited the Palo Alto Phil's Coffee, for those of you who are in Palo Alto. I had the pleasure of working with Will at Palantir. Will is DraftWise's head of product. And before DraftWise, when he was at Palantir, he led Palantir's biggest commercial engagements in the US and EU. He's a Harvard alum, and more importantly, he's a Stanford alum. One of my co-founders is also a Stanford alum. Ozan graduated from Stanford Law School in 2012. He really wanted to be here today, but for personal reasons, he couldn't make it. He practiced as a corporate lawyer for almost 10 years in the US, Europe, and Middle East, focused on banking and finance contracts. While he was practicing, he frequently ran into the problem where the answer he was looking for was somewhere in the firm's past work, but it was really hard to find. It might be a very specific provision that he was looking for, or maybe he was looking for a response in some heated negotiation. So when he met me and Emre, our third co-founder, we put our heads together and realized that this was a great opportunity to bring technology to corporate law. So we started DraftWise. We founded DraftWise during the pandemic, when law firms were first adjusting to remote work. We were part of Y Combinator's Summer 20 program, which was a really exciting opportunity to learn from other legal tech startups in YC, such as Ironclad, Case Text. We started in London, working with Mishkan Derea through their MDR lab program, and later working with Allen and Overy through their Fuse accelerator. Law firms around the world are finding ways to innovate. Just look at the number of high quality accelerator programs that we participated in. And it's not just accelerators. The firms that we talk to, they know the industry is changing and they want to be part of that change. We're not only a company born during the pandemic, but we're also a fully remote company, which is something we're seeing more in the tech industry. Working across time zones, geographies within our team taught us things that helped us enter the global legal market and work wherever there's a firm that wants our help. We started working with multiple AM Law 100 and Magic Circle firms and have expanded outside the US and UK to the EU and Latin America in the past year. It's really interesting how firms have different approaches to the problem of knowledge management. For example, firms in the UK tend to have more central support. They have knowledge lawyers who curate and maintain firm know-how, while firms in the US seem to more readily embrace technology, especially the firms in California. So my background's as an engineer. There's some real technical challenges in this space. Security comes first. The law firm's greatest asset is their past work, and you need to make sure that the data asset is safe and no one accesses material they don't have permission for. This gets tricky, not just because of client protections and compliance rules, but also you want to be able to support the flexibility firms want with sharing resources internally. For us, this is a familiar problem. We dealt with granular access control problems all the time at Palantir. Scale's another big challenge. Law firms have decades and decades of contracts and negotiations and client communications. We're talking about terabytes of structured and unstructured data to work with. And the third big piece is integration. To harness the data law firms have, you need to connect to and integrate their most important systems. All law firms, big and small, fortunately use one of about 5 to 6 document storage providers, meaning that with just a few deep integrations, we have access to and can lock an enormous and incredible corpus of documents in the legal industry. So these are some of the problems that our engineering team solves on a daily basis. Fortunately for us, they're familiar problems given our team's backgrounds in big data, cybersecurity, and data integration.
One of the big challenges we're seeing from an attorney perspective coming out of the pandemic is how do firms collaborate in this new world of remote work? Many firms went entirely remote for a year and a half and are only just now returning to the office. And I think everybody sees a flexible approach to spending time in the office moving forward. So in the old world, people may have been able to train young attorneys, share their knowledge over years of practice with them by just leaning across a desk or meeting at the water cooler, or going through training classes in person together. But that has been either taken away or fundamentally changed, often for the better. More flexibility can be good for attorneys, allows them to spend more time with clients or more time managing their workflow. But firms need to really invest a lot of effort now into thinking, okay, with my attorneys working from home, how do I make sure that knowledge is passed from partners down to associates, amongst associate teams who are collaborating together. And if people change careers, change firms, change practices, that the knowledge that they contributed while they were there is retained by that firm so that it becomes more of that company's particular knowledge. We're spending a lot of time focusing on this problem. How can we make it easy to solve the sharing and collaboration issue, and then easy to solve the discovery of quality language. And I think we're seeing very positive results from associates we're working with, talking about how it's not just efficiency to be able to search faster, but it's actually helping you to draft better when you can get search results instantly, run red lines across comparative clauses, calculate language similarity between different results that you might be looking at. Each of these has complex technical backing, but to the attorney appears as a one-click action that gives them the answer they need without a lot of the data munging, putting them directly to the legal challenges. So what does that actually look like? Going back to James's early 4 questions that we're trying to help an attorney solve. So has my firm worked on something like this before? Whether I'm a new associate learning my particular firm's language, or I've received a contract from the opposing counsel, the other side, and I want to understand, have I ever seen this language before? You want to be able to use DraftWise from within Microsoft Word, within your workspace. Don't disrupt your train of thought. Highlight what you're interested in, click a button, and then have some of our NLP models and recommendation models bring back the best and most relevant matches for your particular deal in your particular language. Are these standard terms for this contract? We are able to pull out the component pieces of contracts, things like the clauses, things like the defined terms, things like the deal terms that you might be negotiating, and actually rearrange those so that you can look at the latest definitions of financial indebtedness across my entire practice group. What are some of the trends in the language that we're seeing accepted, trends in the references that they may be making to case law, and can DraftWise as a platform make it very easy to understand what is my firm seeing, not just what am I seeing? Can I take advantage of everyone's knowledge as a result? What has my client, my partner, or the opposing counsel accepted in the past? Like James said, some of these firms have contract data going back decades, and that really can show you what are your client's preferences. What did they accept 3 months ago? What did they accept a year ago? How has this changed over time? We're able to, thanks to some of the platform that we're building, look at every version of every document that has been negotiated for specific clients, for example, and then help an attorney to understand, okay, in this particular clause, this is how they prefer it. This is what they've accepted in the past. This is what they've denied in the past. You know, these are the issues that I might run across if I try and propose this as a next step. So I have full context now of my client's history. I can serve them better and deliver them better outcomes. And lastly, what other options do I have for better language for a stronger position? Different firms are curating clauses. They're creating clause banks. They're trying to provide people with different negotiating positions, whether you can start with that, fall back, or last resort. And you can curate all of that within the DraftWise platform if you are a knowledge manager, and then make that available and discoverable by an attorney who needs these backup language options. So case studies are always useful to understand how this looks in practice. Earlier this year, we launched to a London firm where we tried to help their knowledge professionals and their attorneys collaborate around their best language using the DraftWise platform. So this is a bit of a two-sided marketplace. On one side, knowledge professionals are able to review what has been accepted across the firm, aggregate that into a generalized recommendation for a particular clause or a particular contract type, and then need a easy way to share that out and put that in front of attorneys at the moment that attorney is trying to decide what to use or what to reference. On the other side of this market are the attorneys who are working hard, are working late, are working across many clients and many deals, and need, when they have the question, the ability to quickly answer, what is my firm's best position on this? What is my firm's blessed language? What should I be using in this situation? And we want to be able to both bridge that gap, start by making it easy to identify curated language, and then to share that and access that. And what's nice is that you start to build a virtuous cycle out of this. If I use, as an attorney, the language that's been recommended to me, that can be considered as an endorsement for that language. If I choose to not use it, choose to use a different language, we can actually say, hey, no one's using the language that you've curated here. You might want to take a look at this, reevaluate its legal efficacy, and consider investing in rebranding that or redrafting that. And so trying to bridge that knowledge gap at this London firm. So looking forward to your questions. Thank you very much for the time. And we appreciate the opportunity to be here today. Thank you.
Thank you. This is very cool. Can you guys hear me?
We can.
Great, great. Well, so I have so many questions, but I want to sort of maybe give priority to some folks in the group. I think Brenton's saying that some in-house counsel that would love a tool that taps into the knowledge base of law firms, so the in-house attorney could have a reference point, or model clauses. How do you relate to the in-house community, and are you seeing a way to open up that knowledge base to in-house folks?
James?
Sure, yeah. So the answer is we primarily service law firms right now. Although through our relationship with law firms, we're working with some of their clients. For example, one of our law firms, one of our law firms has a client who wants to help them populate their own CLM with model clauses, with good fallbacks, with things like that. So that's something that we've been able to help our law firm help their client do. So we're very early in our relationship with in-house counsel.
I think one interesting thing I'd add to that is if you solve the security problem internally, you take good care of contracts, law firms will trust you as a technology provider to open that certain aspects of that to their actual clients themselves. And so we're also looking at what is the interface between a law firm and an in-house counsel that might be possible as a result of the security investments we're making.
Okay. I see Diego has his hand up. Diego, you want to pipe up?
Hello to everyone. I have a question for Will. How do you separate the knowledge from one firm from another? I mean, the competitive advantage that one law firm has over another at the end is the way they redact their own contracts. So how do you avoid like this mixture that the clause that your software is suggesting to one lawyer is not coming from another clause that was drafted from a competing law firm? Thank you very much.
No, this is a great question, Diego. So for any solution, there is both the front end and back end challenges. The front end challenges in our case are making sure we're providing easy to use tools by attorneys. But the back end challenges here are making sure that we have infrastructure for each client. We maintain that data at the law firm itself. So we don't take any data outside of the law firm into a DraftWise environment, for instance. Each law firm is separated from itself in its own data environment that way. So we guarantee that law firms continue to own their data, use their data, and maintain that separation on the back end from possible intermingling.
Thank you very much.
I'm curious. I mean, I think with your system, you could sort of potentially figure out, like, as to how much overlap there's in client needs, right? Like, and how many how many times, clients, need the same thing and need the same clauses, right? And let's say there's, there's a significant amount of, repetition in certain matters, right? Where, clients might think, their situation is very unique, but many times, law firm has seen it many times and worked on the same issue before, and there is knowledge in the firm already. I think so first of all, that would be interesting to know, right? And you have the, potential data to show that, but then it also has big implications for the business model of the firm, because if you have everything, if there's a tremendous amount of repetition and all the building blocks are there, can you really still, sell your product by the hour? So I don't know what you guys think about that. It's more like a comment than a question, but
I think that's definitely in line with our vision. The data is all there, like you said. Lawyers themselves that we talk to, they know that also. They say, they all know that the data is there. They're just grasping for ways to actually interact with it. And the status quo we're replacing is just that hard-earned tribal knowledge you have in your head through years of practice.
Right, and you make it explicit and
right. Make it explicit, make it shareable, make it repeatable, turn it in, turn the average into the floor.
Right. There's some companies out there, that are trying to do things that sort of reach beyond the confines of the particular firm, and they still help attorneys understand what are sort of best practices, or what is the scope or the spectrum of a particular clause, right? What's very, friendly to their client, the verbiage that's very friendly to their client versus more friendly to the other party, right? That's sometimes kind of hard if you just have a static template, right? You don't know what are all the different variations that are possible. I'm thinking about Law Good, which is a company that presented here. So I feel like you're going a little bit in that same direction, but focused on the knowledge base of one law firm in its own kind of confines. Is that fair to say?
Yeah, I think that is. And one part of a law firm's identity is that they probably have a unique perspective on the law. They have a unique history and a unique ability to contribute for their clients. And so we want to be able to help them take advantage of their unique perspective, understand what their unique variance is or what their particular approach to a problem is. But then in the future, see what else we can do across firms as well.
Cool. Sweet. Then let's see. I think you answered. Yeah, Peter is asking, do you model checklists to make sure all key facets of a given topic are addressed and linked to the brief bank?
We're talking about a lot of features around things like guidance notes or version comments, issues lists that you might have through the negotiation process. All of that is interesting data that if you link that straight to the language itself, you can also start to recommend to attorneys, you're about to make this language change. In 8 of the 10 times, it's caused a particular issue tracked in the issue database. So I think we want to move in the direction of adding additional pieces of information like checklists or like an issues list on top of the language. And I think if you lay that foundation and you can appropriately handle language within the platform, you have the ability to do more and more with it if you get the groundwork right.
That's great. Okay, so she's just asking, any thoughts on getting beyond the lawyer market? Oh no, sorry, that's sorry. Any plans on having a non-MS Word solution?
You mean a Microsoft Word replacement or browser-based view, or?
I don't know, Sheesh, can you elaborate, and maybe we'll go over to Mark's question first then until we hear from Sheesh. Any thoughts of getting beyond the lawyer market, for example, tools for unrepresented folks who need to deal with contracts?
Yeah, I think in the same way that we want to make it easy for law firms to share their expertise with their particular clients and the history of their particular clients, we'd also like it to make it easy for them to share their expertise generally with the public. So I think we still take a view that law firms do have a unique perspective. We want to work with them and empower them to be more open. But if we can securely help them identify a relevant set of contracts, share that with the world, share that with particular groups who don't typically have access, we'd love to do that. And then I think that'd be a great use case.
Okay. Yeah, so yeah, Sheesh was talking about browser-based or Google Docs.
Yeah, we have a browser-based view for administrative users, the central knowledge lawyers who are curating for the firm, who are prescribing best practices for the firm. You can administer all that in the browser too. We also have a more advanced search interface that runs through a browser. So many of our users use both, many of our users use one, some of our users use one in some situations and some in others. We don't have plans currently for LibreOffice or Google Docs because none of the law firms we're working with or talking to use those tools.
Okay. So Peter asked also before, that is Peter Vasilko, have you considered facilities to let solos and small firms representing clients on the same side of commonplace matters to share boilerplate? For example, lawyers representing tenants suing landlords for failure to maintain heat or things like that.
We have not yet, but I do actually really like this idea. At the moment, we are making it easy for practice groups or specific teams to join the platform, share their best material, collaborate around that. That would be a very easy approach to take outside of the firm and start to allow people who are participating in a similar case who are maybe across organizations but want to collaborate around shared material and place that into the same environment. That could be a very interesting way of taking this. So I think we have a teams-based approach that works within a firm, but could also work, as you're describing, amongst solos or small firms on the same side.
Cool. Peter is asking how your total addressable market compares to Grammarly for others addressing plagiarism. I mean, I guess what's your total addressable market?
Yeah, it's a great question. I'm not 100% sure what Grammarly's market is, but I think the market that we're testing right now is both large law firms and small to medium firms in, as James mentioned, 6 countries. And so we're trying to see, is this applicable at several segments of the law firm market? One hypothesis is that you need access to historical contracts, but is that actually true if our analysis tools are sufficiently powerful? If I can do a red line in a second over just the clause I care about, do I need 10 years worth of contracts? So I think we're testing that product hypothesis, but we're also testing language hypothesis and legal framework hypothesis. How easy is it to map our current NLP technology to different contract formats around the world, to different languages? And so I think that will help address the TAM question. If it's yes to all of those things, it'll be a much bigger TAM than it would be otherwise. But I think we're going through those experiments right now.
Cool. Ben's asking, how do you deal with bad examples being integrated in the tool and then shared with others? Yeah.
This kind of reminds me of a question we once heard from a law firm we were talking to. Someone asked, what happens if we roll this software out and it makes the juniors so powerful they never really learn how to be lawyers? Like, what if we get stuck in that situation? And the reality we have today is, like, these people are lawyers. They practice law for a long time. They're not going to blindly take the most common language and use it. And then on top of the lawyer's own judgment, that's where our knowledge management pieces to the platform come in. Knowledge lawyers can say, these are great examples. They can add alerts that say, hey, these are bad examples. If you use these, you should instead look at these other ones. So you have the ability in the platform to add more context for a firm to course correct if it needs to, or give them that additional context. as they work.
Yeah, Ben's using the example. He says, like, let's say there's a publicity clause. How do you assess if that was being surfaced by what was being surfaced by the tool is market for this type of transaction? How do you take into context where you have given up on a particular point, let's say in the publicity clause, in exchange for another business point? So do you want to add anything to that, or?
I think looking at a specific clause is a great example. We take the approach where we want to automate as much as we can and then allow you to curate on top of that. So if no one's done any curation and you just need examples of publicity, we want to be able to automatically tell you, is this market? Is this recent? What is the metadata behind the deal where this was accepted? Is it in the same industry? Is it with the same partner? So that's some of the information we can automatically provide. But you should know, okay, there's no additional curation here. I am looking at just trends. Then you layer on the knowledge tools where you can start to have a partner, knowledge manager, an associate dedicated to this role to take all of the options in the publicity clause that we've automatically grouped and provided for you and start to actually say, this is my favorite, this is the best, this is the one that should be endorsed. And now the next time somebody goes there, they might see all 10, they might see the options, but they have that human contribution as well. So do what you can automatically, but really make sure that attorneys can put their legal perspective into the data and into the platform as well.
That makes sense. Got it. Okay, so folks are having actually more questions. We're already a bit over time. If you could perhaps share your contact information, and then so folks could reach out directly to you, that would be great. We have to close here, unfortunately, but yeah, thank you so much for sharing. It's really fascinating what you guys are doing, and I mean, clearly the future of contracting, and so yeah, really interesting. Appreciate you coming in and telling us your story, and also thank you to Beatrice for her presentation. Thank you all, and I don't know, Susan, do we have a call next week, or?
No, we're taking a little bit of a break from the group meetings in November, although CodeX is going to be very active. We've got a couple of speaker events, one at the beginning of the month and one at the end, and then a Thanksgiving in between, and lots of internal stuff we're up to. So watch for us on email with our speaker events, and we'll be back in mid-December with a presentation I'm very much looking forward to, an hour on a legal ontology project. So,
okay. All right, folks. Good to see you all, and see you next time. Thank you all. Thank you.
Thank you.